Okay, so let's take a look at this sales contract for unimproved land. It is NVAR Form K-1209, and the package that you had downloaded, it would be page 21 of that package that we've been using for new contract forms. Has everybody found it? Okay. Now, we're not going to cover every paragraph. Some of this would be basic contract stuff that I've covered before or will be in the next class. But let's take a look at this sales contract for unimproved land. Even
Larry,
though it looks,
excuse me, Larry. Is your session will be recorded because I missed a couple of minutes?
yes, it is recorded. All of our sessions are recorded. So there is a link in that email where you get that I am going to be doing these sessions. There is a link that will take you to all the sessions that I've done previously and today's session.
Thank
so
you.
they are in a Fairfax Realty YouTube channel, and they have the link to it in the invitation to these classes. Okay?
Thank you. Thank you.
Okay. Good question. Corporate, so we're taking a look at this sales contract for unimproved land. Contract is made on the date of offer. You know that is a definition between buyer and seller. One thing I want to warn you about buyer and seller. If it is a corporate owner or LLC, etc., you're going to need some type of a corporate resolution from the buyer corporation to buy the property, or from the seller to sell it. So don't forget to have that corporate resolution in your file, and make sure that their documents are current so that they can even do this, okay? When it comes to the buyer, whatever way it's going to be titled, okay, make sure it's in this contract. Who, among other things, hereby confirm and acknowledge by their initials and signatures herein that by prior disclosure in this real estate transaction. So prior disclosure would be your listing agreement and your buyer broker agreement to represent parties. Okay. Now, one thing I want to point out, in Virginia, we do not have sub-agency any longer. We haven't for quite some time. So when it says cooperating brokerage, if you see that right there in this first paragraph, represents buyer or seller. The co-op broker cannot represent the seller in the state of Virginia. I've asked them to remove that from our form. Hopefully someday they will. So you need to be representing the buyer, which means you need a buyer broker agreement, okay? I'm not going to worry about this dual agency thing here. I will be discussing that when we look at the regular sales contract on Thursday. So paragraph 1, real property. You'll notice that they sell the land and all improvements thereon. I had a question a couple weeks ago. It's really the land, but there's an improvement. Which contract should we use? You use this land contract if the purpose of the purchase is the land, okay? But whatever is on there comes with the property, okay? Described as legal description, you know, you can pull that from the tax records, containing more or less square feet or acres. So we used to call it plus or minus. If you're buying it by the square foot, then it would be adjusted. Or acres, you have to know whether they are buying it, how they're buying it. Are they buying it by the square foot, or is it just a total dollar amount for the property? Then what square footage is stated in the listing? It might be a little bit less, it might be a little bit more, but the price isn't going to change if you're buying it one lump sum. Just know it could be a few more feet or a few less feet when they actually go out and survey the property. And if applicable, together with the items described in the improvements, chattels, and/or equipment included paragraph. So unlike a sales contract for a property, it doesn't list all the things that come. So any improvement will probably come as is. A chattel, this goes back to the old days, back to England, where people were worried about what about their horse and carriage type things. So chattels are movable articles of personal property and or equipment included. So a lot of times if a farm is being sold or the farm land, some of the equipment will come with it. When we sold my father's house in Mineral, we left the bush hog was part of the transaction because there were 38 acres of fields that had to be cut. So that equipment was included in the land sale portion of that sale. But this is where you would list them out, okay? List out everything that comes. If you need additional, then have an addendum, attach an addendum to list it out, okay? Now, price and financing. Generally, these land sales are going to be a cash deal. I mean, if what they're after is the land, I don't know why they have VA, FHA, USDA on here because you know the house is going to have minimum property requirements, and they're not going to be able to tear the house down. So more than likely, it is going to be cash, or you're going to go to the bank, get a land purchase, then a commitment for building, and then finally to a fixed mortgage after it's built. So if it's a cash transaction, down payment would be equal to the sales price, and I think enough said there. Any questions so far? Because this is the easy part. Okay, great. The deposit, paragraph 4. It can be check or bank wired funds. If it's bank wired, it's pretty much going to have to go to a title company. But you may very well be dealing with a note in one of these purchases for land. If I was a buyer, I'm not going to give you a large deposit to be tied up while I'm doing a feasibility study. I would probably offer you a small deposit, maybe $1,000, and then a note due and payable when I remove within X number of days of me removing my feasibility study. Because if I give you a bunch of money up front and I don't like the feasibility study and I back out, then I've got to wait for the seller who's probably mad to sign releases, etc. So this is one time you might very well have a note, which you would have to come up with a note to be filled out, because they don't have one at NVAR on the site. Okay. Any questions about the deposit? Okay, well, down payment. The balance of the down payment, paragraph 6, will be paid on or before settlement date, certified or cashier's check, or bank wired funds. So on or before settlement date. If it's a Saturday, then it's going to be the previous day. Make sure everybody understands the funds have to be there. Now, paragraph 7, with the brokerage fee and settlement statements. In a residential sales contract, it just says pay the money that's promised by the seller on the date of contract. Well, paragraph 7 here is going to be a little bit different. So seller and buyer authorize and direct settlement agent to disperse to listing brokerage and co-op brokerage from settlement proceeds their respective portions of the brokerage fee. Okay, so but each listing broker and co-op broker shall deliver to settlement agent prior to settlement a signed written statement setting forth the fee to which the brokerage is entitled and stating how such fee and any additional sales incentives are to be dispersed. So generally, a title company will send out to the brokers something in a residential houses to be split. But when it deals with land, you need to have your broker send something over as to what the fees will be and how much. Okay. Fees and adjustments. Each party shall bear its own fees and expenses in connection with this contract, except as specifically provided otherwise herein. It goes over what fees are normally paid by the seller, what fees are normally paid by the buyer. I want to point out here in the middle of this paragraph, fees and expenses to be charged will be reasonable and customary for the jurisdiction in which the property is located. Grantor's tax, regional congestion relief fee for Arlington, Fairfax, etc., and Prince William shall be paid by the seller. Beginning July 1st, this fee is negotiable. And remember, they've added that additional transfer fee for this in Northern Virginia. It's all negotiable now as to who will pay that. And if I'm a seller, I may be saying, buyer, look, I'm leaving the area. I'm not going to benefit from all this improvement to the roads, etc. I think you should be paying this fee. So it is a negotiable item now. Okay. Now, paragraph 9 is where we start seeing a big difference between a land contract and your residential. Land use assessment, rollback taxes. If you're not familiar with doing land sales, make sure that the buyer understands this paragraph. Seller represents that the property is or is not currently enrolled in a land use assessment program. The reason a person will put their property in a land use assessment, they're never planning on building on it. They're using it for farming. With my dad's property, 33 acres were in a land use assessment, and the 5 acres his house sat on were not, because we were never going to build on that land. It was used for the horses and the hay and that type of stuff. Therefore, the taxes are reduced. However, if that buyer buys the property and they don't also apply for their land use assessment program, then all the back taxes that were delayed by the seller will now come due and payable by the buyer. So be careful with this one. Make sure if they are buying property to build on and it's been in land use assessment, they are going to probably have a big bill that they weren't expecting. So this goes on to say, if by the actions of the seller, the property is deemed unqualified for land use. So the buyer applies for the land use, and then come to find out the seller had built a structure and property that was in this, then they're probably going to say it doesn't qualify. Then they're going to go back to the buyer and go after the buyer for the taxes. Okay. If buyer declines to continue property in the program or fails to renew or revalidate property in the program after settlement within the time frame required by the local regulatory authority, seller shall not be liable for the rollback taxes. Those rollback taxes are going to be charged to the purchaser. And like I say, if that's been in a land use program for a long time, that could be a sizable amount of money. Make sure that you check this out.
Larry,
Any questions about that?
Yeah.
Yes.
how do you know that it's, I mean, if it's in the land use assessment, how would you know that?
I would check with the county, okay, where the property is located. You might even, well, with this contract, if using this contract, the seller is representing the property is or is not. So if they misrepresent, then they would probably still be liable. That'd be like fraud. But call the county, and
So the
if it's
seller
a
has to
sizable,
The
and if
seller
it's a
has to disclose
sizable,
that.
the sellers has to disclose it in this contract, not by law, but it's a requirement by contract. Okay, so always double check with the county to make sure that, and if you're dealing with a sizable piece of property and the house is on like 5 acres of it, then you should start checking out the rest of the property to see if they're in this situation. Okay.
How to find what amount of money the buyer supposed to be
Check with the county, see how, check with the county and see if this is not continued in the land use and my buyer buys it, they should be able to tell you how much has been delayed and what will be due.
okay, thank you.
You don't want to find out on the settlement sheet, right? Okay. And that's why it's important that if you're going to step outside the field of your expertise, which might be residential real estate, and go into this other areas, that I'm glad that we actually have 65 people on here listening to this, that you highlight these different things that I'm talking about to make sure you double check, or make sure the owner double checks. Because the next one is a study period contingency. And during that study period, they can also check with the county when they check with the county to say, okay, this is what I want to do with this property. The county will probably tell them, well, it's in land use right now. If you take it out, you understand there's going to be these fees. Okay.
Fees for what?
The fee would be for if they had a rollback tax,
Right.
Because they had not used it. You should be finding that in your feasibility study period. Okay?
Fee for feasibility study.
The fee would be the back taxes that have been delayed. All rollback is that, look, we're not going to charge you the full tax as long as you continue to keep this in agricultural use, because you're doing us a favor by not developing property. So they give them a tax break as long as it's in there. But once you take it out of that tax break, then you broke the promise as far as they're concerned. So they want all the back taxes. As long as they go and apply and keep it in the same use. So when we did the auctions for my father's property for his estate, I insisted that the auctioneer include that in their package to people and in their instructions that, we're not responsible for the rollback tax. We've never done anything to the property to cause it to not be. So you better check it out. It's your fee if you're not going to keep this in land use. The purchaser did, and they their attorneys arranged for them to keep it in land use and roll back taxes because they bought it because they want to hunt and do stuff on the property. So now whoever they sell it to might have a different situation. Okay. Study period.
Larry, can I ask one more question, please?
Sure.
On the listing, it's where it says special assessment. Is that the land use assessment?
No.
It's not. Okay, because it
Special
says here.
assessment. Special assessment would be like my house in Arlington years ago. When I moved into Arlington in 1970, okay, into my house, there were no curb and gutters and streets and stuff like the street, but no curb and gutters. They came in and put a special assessment against each property for the cost of this, curb and gutter that went in. So that was a special assessment tax. Okay.
Mm. Yeah, because I mean, well, it's right. Like on this, it's only a 300,000 price, but the tax assessed value is 20,000. Well, that's different then. Special assessment. And, yeah. Okay, that's different. That's different.
Okay. Okay. So paragraph 10, the study period. This is important. I had a conversation earlier this morning with an agent. The buyer wants to buy the property. There's two lots. The lot next door is in a floodplain. Well, if you already know it's in a floodplain, okay, they're not going to be able to build there, okay? So if that's their intent, why would you write a contract to build on a piece of property where you know you can't build? I mean, that makes no sense to me. So I said, make sure you include a study period contingency where they can go to the county and see if the county will give a waiver for them to build in a floodplain. I'm not saying it's impossible, but the cost might make it prohibitive if you did. They also said there was running water on the property, a creek. Well, we have something called the Chesapeake Bay Preservation Act. You can't build anything within 100 feet of running water. So even if it's just a little trickle of a stream in the backyard, you couldn't even put a deck up within that 100 feet, okay? Those are the kind of things they'll find out in their study period. Okay? So this contract is contingent for, I'd like to have 90 days if I could get it, especially with this COVID. After date of ratification, for the study period deadline for buyer to determine whether property is suitable for the buyer's intended use through feasibility. Okay, that's go to the county. This is what I like to do. Will you allow it, etc. Soil, because if it's out in the country, what perk can we build? Are utilities there? Or any other studies or testing necessary for the buyer study period. We now know marine clay is one of those. I'm not telling you you should check. So make sure the soil allows whatever, okay? Such studies or tests shall be pursued diligently and in good faith. If buyer and buyer's sole judgment determines that buyer's intended use of the property is not permissible or practicable, buyer shall have the right to void this contract and the deposit returned and no further liability or obligations except as set forth. Now, this is imperative, folks. In such event, buyer shall or shall not deliver to seller all documents related to the test and or studies conducted during the study period. If I'm the seller and I'm allowing you to do these studies, then I'm going to want those documents given to me if you don't go through with the contract, okay? Now, the buyer might say, I paid for them, they're mine, I'm not giving them to you. So, but if I'm the seller, I want them. But real important now, and this is on page 24 of that handout, page 4 of 10 of this contract. If buyer does not void the contract by the study period deadline, this contract will remain in full force and effect with no study period contingency. They cannot miss it, okay? It's defined in our sales contract, okay? And if on page 8 of 10 of this one, definitions, okay? Definitions. And for the purpose of computing a time period, it is 9 p.m. on the day specified. Not 10 p.m., not 11, not 12, it's 9 p.m. And the day start the day after delivered. We have to go by what's agreed to by buyer and seller in the definitions. Don't take this up to the last day in case you counted wrong. They may have lost their right and might have to be stuck buying a piece of property that is useless to them. We had a situation here several years ago for a piece of property over in Tyson's Vienna area. And the purchaser bought it to tear the house down and build another house on the lot. Unfortunately, there was floodplain on the property. So they didn't find out until settlement that they could not build the house. They could tear down the old house and build a house the exact same footprint, but that's not what they wanted. So here they were with a piece of property that they paid tremendous amount of money for, and nobody ever did a study. And floodplain is so easy, folks. If you go to your RPR that's available to all of us, you do a property report, and you put in floodplain, it will superimpose the floodplain right over the property so you know whether it's there or not. So please make sure that these study periods are done in the proper amount of time. Give yourself time to do it. And all engineering, surveying, topographic, site plans, soil testing, any of that information in the possession of the seller will be made available to the buyer within X number of days of data ratification. It will not be made available. You're representing the buyer. You want any reports that the seller already has, okay? If they have any reports, make sure you get them. Now, I recommend the owner hire somebody, pay a little money that helps them do these studies. There are companies out there that will do it. There are lawyers out there that are good that will do it. And I know it costs a little bit of money, but if you're investing a lot of money in a property, you want to make sure you can do what your intended use was. Okay? Any questions about the feasibility study? Should
Yes,
never buy a piece of property that doesn't have a feasibility study. Yes.
If you are as a seller, how many days would you do it? Like you said, 90 days if you are buying would be good. But
well, they're probably going to try to hold you to 30, but you know, I don't know how you can get a true feasibility study done in 30 days, especially in this COVID stuff. And the county may not have full staff, so you got to allow yourself some time. If I was a seller, I'd probably compromise, try 45, but all you're doing if you try to cut it too short as a seller is going to end up having somebody void a contract on you.
right.
So,
So reasonable would be 45?
I don't, minimum 45, I think, to get it done, in my opinion. But like I say, as a buyer, I'd want at least 90.
Okay.
And the reason being, you might have to extend. Here's a problem. If they do what we call a phase 1 environmental study.
Excuse me, Larry.
Wait a minute. Let me finish answering this question.
Okay.
So if they're doing a phase 1 environmental study, okay, and that just means to go out and walk the property. If they find anything suspicious in a phase 1, then they're going to do a phase 2. Now we're talking engineers, a whole lot more soil testing and whatever. You know, you could always extend the period by an addendum, but be careful. Okay. Yes, sir.
The gentleman was asking you about the study period time. Is 30 days good, 20 days good, 45 days is good? It depends to the size of the lot. I'm selling a lot is 47 acres. And for 47 acre study period cannot be like 20 or 40 days. They like 90 days, or this is negotiable.
And that's why I said I would want at least 90 days, no matter what the size of the property. But if you got people countering back and forth, and they say the only way I'll sell it to you is this, then that's the buyer's got to make that decision. But I would never do one less than 90 days. Okay, especially now with the COVID out there, with the lack of people at the offices and finding engineers and people to do these studies. So that's why you've got to be. That's why I recommend that you have a professional actually help you with the studies,
Right, the study
rather than an owner themselves just doing it by themselves.
Who is professional?
Oh, hold on. He's not.
I'm
They
sorry.
mostly include the financing on a study period and all.
Yeah, well, financing is a separate contingency. Okay.
Right, but they put it all together usually.
Well, yeah,
Or
financing with this contract is back in
Or
paragraph
commercial
3.
land.
So, you know, and I didn't cover financing too much here. You're probably going to have to go to a regular bank. They have FHA, VA, et cetera on there. You're not going to get an FHA, VA loan or anything like that on land. So they pretty much copied that from the regular contract. You're pretty much going to have to go to a small local bank or some other lender to get this land loan, and then they might switch that into a construction loan and then a final at the end. But that's another step that you almost need help with if you're not used to doing this.
Yes, thank you.
Larry, you said professional. who is professional who could
You
help
can
us?
Google people that will help with the feasibility studies, or get a land use lawyer,
Okay.
okay, a land use attorney that will help you through this, okay. And especially as we're talking about, if you're talking 50, couple hundred acres, etc., you really got to know what you're doing. Unless you're just buying it to leave it lay out there and put it in land use, and you can do it. Even with the land use paperwork, even though you could probably fill it out, I'm probably going to have an attorney help me even with the land use part of this contract. Okay. Now, access, paragraph 11. Okay. Now, this means that they're going to allow the engineers, surveyors, everybody else to come in. And any damage done to the property has to be, restorative. I mean, if they're going to have to drill and whatever, you repair that part of the studies. And I'm not going to sit there and read.
You froze.
I froze. I think. Everybody hear me still?
Yes, I
I
hear you.
cannot hear. Is
Well,
anybody here?
Everybody else said they can hear me.
I hear you, Larry.
I can hear you. Yes.
I hear you.
Okay. All right. So I didn't freeze. You did. Okay. All right. Let's go to the hazardous materials paragraph. Another thing that you have to be careful. Now, if it's farmland out in the middle of nowhere, you may not have a problem, but farmers had a tendency to bury stuff and burn stuff and do all types of stuff. But seller hereby expressly represents and warrants to buyer that during the period of the seller's ownership of the property, seller is not used and seller had no actual knowledge of others using the property for landfill, dumping, disposal activities, operations, storage of raw materials, products, waste or hazardous nature, etc. A lot of farmers, had burn pits, buried stuff. I mean, it's just the way it was done in those days. But if your seller knows they have done that, then I would disclose it so it's not discovered later, right? Because you don't want them coming back to go after anybody. And seller is agreeing to identify and hold the buyer harmless from any and all cost, expenses, and liabilities that may be incurred by the buyer as a result of the breach of these representations. So disclose that they've done anything. Okay, the risk of loss paragraph number 13. The risk of loss. This is a little different than our residential contract, okay? In the event of substantial loss or damage to the property before settlement, buyer shall have the option to either terminate this contract and recover the deposit, or affirm the contract, in which event seller shall assign to buyer all of seller's rights under any policy or policies of insurance applicable to the property. So if there was a structure on the property and there was insurance and that property was damaged and there's going to be money coming in, the buyer might say, just, I want that money. I'm going to continue to go through with this transaction. Okay. Whereas ours says the seller must keep the insurance on the property because of equitable title rights in the state of Virginia. This gives an option to either go forward or bail out. Another example might be we had one time where the land was being purchased for the timber, and a tornado came through and took out quite a bit of the timber where it wouldn't be marketable now. And the buyer actually backed out because the purpose of the contract was to farm the forest. Okay, so you never know. Now, another difference in this paragraph versus paragraph 20 of our residential sales contract, you will find on page 5 of 10. Okay. First paragraph at the top. Nothing herein shall prohibit the parties from mutually agreeing to extend settlement date under terms acceptable by both parties. Seller will convey the property by special warranty deed or by general warranty deed with the English covenants of title. If I am a seller and I am selling something, I'm delivering a special warranty deed. Do you know the difference between special warranty and general warranty? Okay. Your buyer needs to know the difference. Special warranty simply says, I have not done anything to encumber this property during my ownership. I don't know about anybody before me. I'm not guaranteeing that. General warranty is saying, I'm guaranteeing it against all time and all parties. I'm not going to do that. When you buy a new home, what type of deed do you get from the builder? You're going to get a special warranty deed. They're not going to guarantee it against all time. So be aware of the difference between special warranty and general warranty. Okay. Any problems with that? So
Mr. Larry,
paragraph, yes.
Mr. Larry, isn't it that when you purchase and you have a loan under the land, then it comes with the insurance that cover the general warranty?
Well, it depends. Depends on whether they require a general warranty deed or not.
Okay.
And if, with a loan, the lender is probably going to protect themselves the best they can. But if it's a cash transaction, which a good part of these things will be, then you got to protect yourself by.
Then if
ask
it's a
for
cash transaction, you have to tell the buyer to get the insurance, the warranty, general warranty, to be covered for all the things.
Well, either that or make sure they get good title insurance.
Okay.
And don't get cheap on the title insurance.
All right. Thank you.
Okay. Because a lot of times people try to save money by not taking out title insurance, a one-time fee to protect themselves, which doesn't make sense to me. Okay.
Larry, what period the general warranty will cover?
The general warranty covers basically everything. Say that it was a piece of property sold in Arlington years ago, and this actually happened, where the gentleman knew he was dying, okay? And the land was only in his name, okay? That it appeared, and so, but, he was married, tenants by the entirety, and they asked him if he was married, and he said no, because his wife had a different last name, etc. And his property was sold. They built a big high-rise condo building on the property. And after it was completed, the wife showed up and said, "What a nice building you built on my property." Okay. And anybody that had title insurance, they protect, the title insurance company protected their interest in the property. The people that didn't were out on their own. So, I mean, it could be an heir that nobody knew about. They thought somebody had died and he hadn't, etc. There's all types of things that can pop up. Don't talk about a title insurance. It's a small fee to protect your investment, especially if you're putting a large amount of money down. Okay, and the lender's going to require it on their loan anyway, right?
Larry, I was told by a client who was a lawyer, he said, we don't need both. Like if the loan has a title insurance for the bank, you shouldn't get another one because it's already protected during these 30 years of the loan. Is that true?
It protects if you have no equity in the property, then what do you care? You don't necessarily need it. But if you're going to have any equity in the property, you put money down and somebody comes back and has title, you lose all the money you had. If you have to defend the title, you have to pay the expense of the attorney. So the attorney said, don't get it. Well, of course not, because they can defend themselves in the title. I would never buy anything without my insurance on my part to cover my equity in the property. But it's got to be a judgment call. But I don't want any of our agents telling people you don't need it. Okay.
Correct. Thank you.
All right. Paragraph 18 is FIRPTA. Okay. If you remember FIRPTA, we'll discuss this when I go through the regular contract. If someone is a foreign person in the sale of a property, then up to 15% of the sales price have to be withheld, and the buyer could be responsible for that money if it's not collected, etc. I will cover that later. Paragraph 19, notice of possible fine of mechanics lien. This actually spells it out. our sales contract for residential mentions it, but this spells it out. So anybody that did any work on that property or supplied any materials has the right to put a lien against the property. And they have up until 90 days from the last day of the month that they worked on that property or they did supplied any material to file this lien. Then the lien runs with the property. So the problem here is if your buyer settles and there was anything done by a contractor or a supplier, they could come back after settlement, put the lien against the property, and at that point, the new buyer would be responsible for that lien. Now, once again, if I get the best title insurance policy out there, it's going to cover these problems. Okay, and most purchasers aren't the most savvy when it comes to this type of stuff. If you deal with this every day, you might be better. You might be willing to take the gamble, like an attorney or whatever. But even though I know most of this stuff, I would not feel comfortable doing it without it. They did add Megan's Law here. That's sex offender law. It's not included in our regular sales contracts because it's disclosed in your buyer broker agreements and listing agreements. People have the right to check it out. Paragraph 22, assignability. Yes. Yes.
After, you said after, 90 days after what? After settlement or
No.
after
No.
you put a lien on that?
It's 90 days from the time, the last day of the month where they actually did work or supplied material. So this is what, July 7th? So the contractor worked on the house on July 7th. You go to settlement on July 15th, okay? Well, from the last day of the month of July, plus another 90 days past that, the person that did the work on July 7th can come back and put a lien against the property for anything they've done. And since your buyer's already settled, that lien runs with the property.
90 days,
so
so 90
they-
days from the last day that they worked.
90
or
days from the
supplied.
last day of the month that they did the work.
Last day of the month, okay.
Okay, so most of the time, at all settlements I've ever gone to, they have to sign a statement they haven't done anything to the property and whatever. That's just like in a regular contract, okay, for a home. You come up with this $20,000 worth of work that has to be done, and they get a contractor out there and they do it, and that contractor hadn't been paid. After settlement, they could come back. So they're supposed to supply the receipts, etc. That's why they have them sign off all these things. A new home, they have every contractor sign a release of liens statement. So just be aware that it could happen out there. All right. Assignability, paragraph 22. In our sales contract, okay? In our sales contract for residential, it says the contract cannot be assigned without the permission of the seller. This is entirely different. This contract may be assigned. In the event it is assigned, the original parties to the contract remain obligated hereunder until settlement. So I may find a very good deal on a piece of property. I lock that piece of property up. I can sell my contract without the permission of the seller. Okay? So, but I am still obligated under the contract to make sure it goes to settlement. So the party I sell the property to may not go to settlement. Well, then I'd still have to settle because I'm still on the hook. But I don't need that seller's permission to sell my contract, unlike residential where I do. You understand? So therefore, when it said all brokers had to send over their commission requirements, it could be where I flipped it, okay? And there's an additional fee. So, but I have the right to sign my contract without permission. If you don't want that in your contract as a seller, then cross this paragraph out. So there's a lot of boilerplate stuff here that you have to understand. On paragraph 26, time is of the essence. as to all terms of this agreement. There's no definition of that here in our contract, but it means dates and time frames are written in stone. Can't miss them. Residential, they actually spell it out. Okay? Now, paragraph 28 is where you would acknowledge that you have an active or inactive license. And that means any party to the transaction. If a corporation is selling a property and one of the owners of the corporation has a real estate license, whether it's active or inactive, they would have to disclose here. Okay. It is also saying real estate licensed brokers may deal in other things like loans or settlements. They may be receiving some money from that. Once again, if that is the case, then Fairfax Realty has a form that would need to be signed if they're using any of those additional people like the settlement company.
Larry,
What?
if any friend is buying the house, the land, they don't have to declare, right? That he's a friend of mine. Real estate buyer's agent has
A friend? No.
only the
But
relative,
but
right?
related to or a licensee, yes, but not related to. I mean, not just a friend.
Thank you.
Okay. Now, paragraph 30, they have an appraisal contingency for all cash. Remember, that's one of the new forms they came out with, an appraisal for all cash. Okay. So make sure if they want to have an appraisal on the property that you use that separate addendum form. Okay. And that's the basic differences that you will see as a residential agent selling in, unimproved land versus selling a house. Any questions about any of those? The ones that really be careful about your feasibility studies, okay, and land use assessment, rollback taxes, and hazardous materials. So really be familiar with those paragraphs.
So my question is, I'm going back to my residential contract. Title,
Uh-huh.
the title has to better to buy it, right? It's good to buy the title.
The title has to what?
They have to buy the title. For the just nobody can sue them back later on, right? The closing title, whatever called.
Well, they could
Title
sue 'em.
insurance.
You mean talking
Title
about the title insurance?
Right.
Well, they
Sorry.
could sue them, but look, if you only have the lender's title insurance, right? The lender's covered, okay? If you don't have the owners and somebody comes back and sues for title, because they said, no, I had an interest in this and it wasn't cleared, well, then you have to hire attorneys to take care of that unless you have the title insurance. If you have the title insurance, they defend you, okay? The likelihood there'll be a problem is small, but you don't want to be the case where you have to hire attorneys and pay damages and that type of stuff.
Okay,
Okay.
Larry, I have a question.
Yes, okay?
Please, to paragraph 22, can you go back again? Can you explain it again, please?
Paragraph 22.
Assignability?
Uh-huh.
Yeah, paragraph 22.
Yeah.
Can you please go back and explain it again?
Okay, so in the residential contract, it specifically says that you cannot assign this contract unless all parties agree.
Mhm.
In a land contract for purchase of land, this contract may be assigned. I don't need the permission of the seller to assign it. So if I can come in and I can negotiate a good contract and then I can flip the property, I don't need the seller's permission to do that. As long as they show up at the settlement table. I'll give you an example. I bought
Yes.
a piece of property over in Clifton back in the 70s, a 5-acre lot. Okay, and I was going to build on it, but my wife had a problem with the high tension power lines that run down there. You could actually hear them buzzing. Didn't bother me, right? But she decided she didn't want it. So I didn't want to back out of the contract, but I had the right to assign it. And I found somebody else that would take over my interest. I didn't make any money out of it. I just, I was buying it from a friend and I didn't want them to have to start over. I had to make sure they showed up at the settlement, okay, in my place. So they actually were the buyers at the settlement table, okay. But if they had backed out, I would have still had to go to the settlement table and buy, okay. So in the event it is assigned, the original parties remain obligated hereunder until settlement. Okay?
I see. And you don't need to sign any paper. You don't need
No.
to show anything.
No.
Okay.
No, but you wouldn't have to inform the title company of the
Yes,
Of
of
the
course. Yeah.
of the chain of purchasers.
All right.
Okay?
Great. Another, if you have some time, another question.
Sure.
I'm listing a condo in an area that it was a part of it was under fire. The apartment was under fire partially, and the balcony still have some work need to be done. And they haven't really got the approval from the Fairfax County to do the work. What kind of paper that I would need if I'm listing this condo?
Well, you know of that. So the law says if you know of a known material adverse fact about the physical structure of the property, you as an agent must tell everybody in writing. That doesn't mean you have to put it in the listing itself, but
Okay.
make sure in writing to the agents, etc., that this is here. I would put in my listing, please contact listing agent for important information before writing contract. Okay.
Okay.
But you know that this work has to be done. It should show up in the condo docs also, but to me that's a known material adverse fact about the physical structure, and you as an agent have to tell everybody that in writing.
So do I have to put it in the description when I'm
No.
putting the listing? No.
No, that's where I would say contact listing agent for important information.
Oh, contact listing agent. Okay.
So
All right.
and then send it in an email to the parties that this has to be done.
All right.
Larry, this is
Is there already
Andrew.
a special assessment? Is there already a special assessment for the work?
They have not come. I think they have not come with that yet. They have.
Okay,
They are,
and because the problem is anybody that buys it, if that special assessment's not in place prior to settlement, then that new buyer is going to be responsible. If the assessment's in place, then and it's paid in payments, that's another thing that has to be considered. But if the assessment's in place, then the buyer is going to be, seller would be responsible for it. So there's a lot, the buyer should know about this.
okay. And I should, okay. All right. So I should contact the homeowner association to get all this information.
Sure, yeah,
Okay.
I would. I'd have it at my fingertips
I hear.
because
Okay.
you know.
Yeah.
I mean, if you were a buyer and you found out afterwards, would that have changed the way you wrote your contract or whatever? Probably, so that they would come after you and your license, not the seller.
Yeah, I understand. Yeah, that's what I'm trying. I want to see if there's any form, any disclosure that I need to put in.
No, there is no actual form.
No
Just
actual
says
form.
has to be in writing to all parties to a contract.
I hear. Okay.
Okay.
All right. Wonderful.
Larry,
Larry.
Larry, can I
I-
ask you a question regarding rental showing?
Okay. My
There's
favorite
a-
subject, rentals.
Um,
Okay.
the tenant is in the property now, but they're moving out in the end of the month.
Uh-huh.
And I have put the property on the market. They don't want to show. So
Yeah.
what if there are potential renters wanted to see the property? What is our official recommendation during pandemic?
Well, I would not. I don't think that the tenants are going to allow people in. I would probably ask them if you could come in and do a virtual filming of the property and let people see it virtually. Do it with your phone or something or another. But if not, you may not be able to get anybody in here till the end of the month. I know that the
So
lease says that. I know they said they have to let people in by the, you know, and that would be a violation of the lease, and you could evict them, but you can't evict them because you can't get in court to do it. So everybody's got to be somewhat, you know, understanding with this COVID thing. Quite frankly, if I was a tenant, I wouldn't let anybody in my property until my lease was over, especially being 73 or older like I am, you know. So
can I ask them, just
that's
say,
my excuse anyway.
I mean, I don't want to show it either because I'm not that strong. I don't want to contract corona, but can I ask them, say, if she can just do a virtual like showing with the tenant? That way I don't have to go in. She
Well,
doesn't have to get any
And
contact.
that's what we recommend as a virtual showing, if they will allow that one party to come in and actually do the virtual showing. Is it a single family home or is it like a condo?
Single family home.
Yeah. So, you know, that would be the compromise if they will agree to it.
Okay.
I mean,
So
these are
is there
different
a
times, you know.
company? Is there a company you recommend?
Well, there's a lot of them out there will do it, or you can just do it on your cell phone.
I can just do it on my cell phone, just record everything.
Yeah, you could go do a recording of the property on your cell phone and download it to your computer, right? You computer people?
I just don't know how
My
is the
granddaughter-
way of conducting showing right now, because
Yeah, that's what we recommend is virtual showings. And
virtual showing.
my 10-year-old granddaughter was showing me how to do all kinds of stuff on my phone over the weekend. So,
Kids are too small.
she said, you don't know how to send a picture? I said, no. So they show me all kinds of stuff. You know?
Yeah.
Mr.
All right,
Hanson,
thanks.
Yes. So,
Mr. Hanson, I got couple of questions.
okay.
In the residential contract, you know, before we go to closing, what is the best time to go for walkthrough before we go to the closing?
Well, it says
Then
you have
they
the
are-
right to. It says you have the right to do walkthroughs 7 days prior to up to 7 days prior to settlement. And it's walkthroughs, not one. If there was work had to be done by the buyer, by the seller, I would recommend that you do more than one walkthrough to make sure the work is done. And even if you do a walkthrough 3 days before, you need to do a final walkthrough on the way to settlement to make sure no damage is done when people left the property. But the contract allows you to do walkthroughs up to as far as 7 days prior to settlement.
Right, 7 days. Okay. Another question. What happened if we do the final walkthrough Monday before and next day, in the meantime, earthquake comes in and something happened in the house? Who's
Well, if they
responsible?
settled, if they settled, then and they didn't do a walkthrough on the way to the settlement, then it's going to be their problem.
No. If we do the walkthrough 1 day before, buyer does
Yeah.
the 1 day before and the in between next day, we do the settlement. What happened in between if earthquake comes in? Who's the responsible?
You go back. You lost me there. You did the final walkthrough the day before.
Yes. And in the meantime, something happened to the house.
Well, how are you going to prove when it happened?
Well, earthquake comes in or something happened.
Well,
I'm
if
just saying.
if it's an earthquake, then why did you people go to settlement without going back to make sure the house was still
No, I'm
standing?
just asking, you know, I'm giving you example. No, I'm just giving you example, you know. This is my example, you know.
Well, you know, if it's something like that and they settled already, they're going to have to go back and try to sue someone. But you know,
No.
hey, I mean, there's something that's in the contract about, you know, if something, you know, like that happens, that you know, then the property couldn't be delivered, then your purchaser probably had the right to void the contract. But because the seller can't deliver a property that's not, you know, happening. But if they settled on, you know, that's going to be a messy problem.
That's
And
a
that's why
different
when
case.
people-
Yeah.
It
Okay,
means
thank
doesn't matter what, you have to do walkthrough at the last day.
The
Okay.
best is
I always
2 hours.
I always do multiple walkthroughs. Okay. But I always do a final walkthrough on the way to settlement. to make
Mhm.
sure that there was no damage done when the people moved out, or
Right.
they didn't take something that they weren't supposed to take. Okay, but I
Current-
also make sure the other agent understands that we will be doing, you know, a walkthrough, say maybe 4 or 5 days prior to see if there's anything that has to be fixed, to give the owner time to fix it, and we will do another walkthrough on the way to settlement. So
Okay, thank you.
I'd
Great.
let them know. You know, don't just try to slip things by. Just let them know.
Great, thank you. Appreciate it.
Gary, this is Andrew. I got 2 questions.
Okay.
At the land contract. Question number 1, how do you handle perk? Number of perks required for multi-acres. That's
Well,
question number
perk,
1.
you're gonna have
Question
perk.
number
You're gonna have
2.
to get a perk. You're gonna have to get an engineering firm out there to do a perk test, because you know, it may will it perk where you want to build. It might be a place on the property that will perk, but it's near running water and you can't build. So you need to have a company to go out there and do it as part of the feasibility study.
Yeah, so how do you handle in contract? Put it in a contingency plan?
Well, it's in your studies period that you have the right to do the perk test.
Okay. Next question.
Uh-huh.
Any do and don'ts for owner financing to purchase land?
If owner financing,
It's almost like an installment sale.
yeah, it is addressed in the contract. Okay, what's going to be required if they do it. And if I was a seller, you know, I make sure they gave me all kinds of credit reports, etc. But I would also probably use a standard Fannie Mae note and deed of trust. You know,
Okay.
what we call a cross default clause, so to protect myself.
All right. Thank you very much.
But owner financing is covered in this contract. What has to be given to them and done, etc. So, so I would go by that language. Okay.
Okay.
Any others?
Yeah,
Yes.
Larry, Mr. Anderson, I'd like to know if tax form, they have a 2 people name on there. Presidential contract says, I'm sorry, not presidential. When I fill out the contract, two people's name on the tax form, and I send the form. Suppose I send the form, he say only 1 person name on it. So the settlement people will do the survey and find out whether they have.
No, if there's 2 people on the title, there's got to be 2 people on the contract. You can't sell a property unless you have all parties that own it agree. So what you need to do is contact the listing agent and say, look, the tax record showed 2 people on this. Why is 1 person selling it? Might be a logical reason. Might have been a divorce and 1 party
Right.
signed over the rights, or it could be whatever. But you can't go forward with a contract where only 1 party signed the listing and 1 party signed the contract if multiple people owned it. We discussed that last week when one owner listed the property with an agent. They put it on the market, but brother owned it with them. Well, there's no listing. You know, you've got to have both parties to it. So that's why you need to check your tax records and see who the owners are, etc.
So it should be 1 name, not 2 names. If there are 2 names on it, he can give the quit form, right?
If there's two names on the tax records, there should be 2 names on the contract, unless they can show me why they own the property without the other party anymore.
In case something
Because
divorce
you
happens.
have to understand that tax records are behind. Okay, so there could have been something recorded where the other party had, bought the one out, they now sole owners. But you've got to ascertain why you don't need both names.
Okay, so we can ask the listing agent the other quit form or something like that.
I would ask the other party point blank. I guess I'm a little bit more straightforward. I'd say, look, tax records showed 2 people own this. Why is there only 1 on the listing? And why do you only want 1 on the contract? You got to have something. Give me something from the court saying that this other party is no longer an owner.
So that settlement doesn't have nothing to do with that. They will do the survey or anything.
Well, the settlement won't settle a property if there's 2 owners and only 1 of them are there. They need everybody to sign the paperwork.
Right. Okay.
You find a title company to do that, they're not going to be able to very long. Okay,
All right. Thank you.
questions?
Yes,
Okay.
Larry, I have a question.
Okay,
This is
alright.
Carmen. So I was working on an offer yesterday, and the listing agent sent me the property disclosures statement, but she used the old version, right? Or she had the old version. So what should I do in this case? Should I ask her to give me an updated one, or should I just
Well,
provide it to her?
I was looking at the form. They
Mhm.
didn't change the date on the bottom, but they
Right.
changed the language. Now, what was it dated prior to July 1st by her sellers?
It was dated July 2nd, but actually the form itself said revised October 2019.
Yeah, I know, and they did not. They changed the language on the form, but they did not change the form. I don't know what's going on with that.
Mhm.
So I would say just go with it,
Okay.
because as long as it's said at the bottom, you know, you've been advised of the language they changed. You've been advised as to what's in this statement. You know,
Okay.
and the other said you were advised to check into it. This one says you've been advised, and I saw the language was changed, but not the date on the bottom of the form, which really surprised me.
Okay, so
'Cause
I just go with it.
That's a DPOR form.
Mm-hmm. Okay,
But you know, they're short staffed too. Maybe the proofreader wasn't there.
right. Okay, well, thank you.
Thanks, Larry.
Okay, well, thank you everybody for attending. We
Thank
had a good group today. Thank you.
Thank you.
Thanks, Larry.
Thank you.
Thanks.
And
All-
Thursday,